Go ahead.
It's gonna be.
Mr. Solomon, thank you. Yeah, he can have a seat right over here.
Authority of the police officer to use power and this has been so busy.
You're late. The warrant is issued for your arrest. Really? Really? I mean, sexual assault of a child, prostitution, online solicitation of a minor. You're charged with those very serious, and you're ambling in late. Really? That's the way you take care of your business? That's what you think about and the importance of these cases? Well, that's why a warrant has been issued, and you're in timeout right now until we can get back to you here in a little bit, okay? When, failure is not an option. Thank you. That's going on, that's on the trial. What is his name?
Holden.
Holden.
I'll give you that call.
Okay, what did we do? We revoked his bond.
Yes, sir.
You were not here, and when we called your name here in the courtroom and out in the hall, what's your problem?
I have to catch the bus to get.
What are you saying?
He said he had to catch the bus and he missed the bus.
Well, that's you can't blame the bus driver. What else?
So that's it.
Okay. Did we? We didn't. Okay. What are we gonna do on this?
He's saying.
What do you want to do?
He was on the trial dock.
Okay, it'll be set for trial. And we need to just hang loose until we release you for the trial. Mr. Adams is your attorney. He can continue to represent you. He'd probably go to trial quicker if you agreed to release him, and someone off the trial docket wheel. The next person would be assigned today, but it's your call. You want to keep him or not? Your call.
He said,
Sir?
he said he'll release me so to go
Is
fast.
that what you want to get it? Okay, then I find good cause to, you talk to Mr. Adams about your options here. Then I find good cause to release Mr. Adams. The next person on the trial docket wheel will be assigned to represent you for trial. Just have a seat before you leave, and if all is well, then get a resetting and we'll place it on the trial docket. Thank you. Okay, where's Mr. Solomon? Come on up.
And this
Who is his attorney?
Um,
Brian Gertz. We'll have to call him.
Okay.
You have failed your drug test. You have tested positive for methamphetamine and amphetamine. Your bond is revoked, and zero bond. You must have a drug patch as a if you will have to have a drug patch. I'm going to have a hearing on this when we can get Mr. Gertz, and we'll take up the issue on what bond conditions, if any, or matters that would be, the court would be willing to consider. And this was off the trial docket. So we're going to get this straight for the record. You were coming in here for a trial today, and you're testing positive for methamphetamine and amphetamine. And I can guarantee you, sir, that your moral compass is out of whack if you feel like this is the way you should handle something important like trials, which are of sexual assaults of children, prostitution, and online solicitation of minor. You handled your responsibility. He tested positive for meth, amphetamine, and amphetamine, and his bonds are revoked. And
Your Honor.
no, don't talk to me. Talk to him before you start. This is a scientific test.
I don't deny.
And all right, you really have to work on handling your responsibilities and issues more like an adult should.
Good
Okay,
things happen in my life. I stepped up.
all right. And I'll put it on a hearing for later, but right now, no bond on a trial docket day when you're testing positive. What were his bonds originally?
50,000 on each case.
50,000 on each one. All right, put this on Wednesday.
This one, see?
Yeah, can we, for a bond hearing, a hearing on bond. When can you be available?
I'll be here in another hearing on Wednesday.
Okay, we'll pick this up. We'll bring him back on Wednesday so that we'll get out of his system. And we'll be, because we're not gonna release him out anywhere while he's testing positive. All right. That's on that.
I used it.
Talk to him.
Yeah, no, Cal lives, I can-
Okay, next, is
And then-
Mr. Son,
Name of the link.
Leroy Holden. Leroy Holden.
He was on the trial. So,
Yeah, you were on the trial docket too, right?
Yes.
Hold on.
Well, just give me on Wednesday. I'll come back because I've been hearing on Wednesday, but I'm gonna be filing a motion. Okay.
Okay. So, okay.
I think I handed you this
Oh,
file.
yeah, I'm looking at the trial docket. Leroy Holden, Mr. Adams, where's Langston?
He left though.
You tested positive today too in your drugs. You've got cocaine in your system. And as well, you were placed, this was a trial docket. And the same railing on I'm going to do for you. You cannot, first of all, you failed to appear. Now you've appeared. When you've appeared, you have drugs in your system on the trial docket day, which means we couldn't try your case with you being tested positive for illegal drugs anyway. So what is his bond? Your bond is revoked in this case.
We did a no bound last time. Let me look.
Well, he failed to appear.
Yeah, yes, sir. I just $30,000.
Okay, your bond is now $100,000 for your drug usage on trial docket day. If you post a bond, you will have to have also a drug patch as a condition of your bond. You were taken into custody.
You've already brought her up here.
I brought.
Where's she?
She's ready.
Is she inside?
She's
Or where?
already signed up.
No, is she in the hall or?
Everyone's in custody.
All right, let's do, we can only do one at a time. She's in custody? This one at a time. Take the one they're working on. Who is that?
Brewer.
That's Brewer.
Okay.
He signed up too.
23 CR 1495 is now called, the state of Texas versus Lyndon Paul Brewer. You and Mr. Brewer
Yes, sir.
with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment?
Yes, sir. Yes, sir.
And can we proceed in summary?
Yes, sir.
Okay, he's third degree felon. It looks like he's an habitual felon.
That's correct.
What are
Your
we doing?
It's gonna be, the agreement was 5 years TDC. He had
So
been
he's
on.
looking at 25 to life?
Yes, sir.
That's a pretty good deal.
In this case, I believe he had spit on the police officer there. Is what just giving you
Who
the
enjoys
circumstances.
being
Yes, sir.
spat upon.
Yes, sir.
Go ahead, say something. You didn't do it or not?
No, on my life and my kids, man, I don't want to throw my life away.
Did you do it or
Put some
not?
spit on a woman. I didn't spit on a woman.
Did you do it or not?
I didn't do it.
It's set for trial.
I didn't do it.
It's set for trial. This lady has a chance to be heard.
Guilt, but I didn't do it.
The
I just
lady,
want to free my soul before I see my.
all right,
That's
the
all I'm
lady-
gonna do.
the lady will have a chance to be heard. You're not gonna say you didn't, you're not gonna say you didn't do it and plead under oath you did, sir. We're setting it for trial. It'll be set for trial.
Maybe said, "Trump."
Yes, that's what we're gonna do. Let a jury decide.
So I should say guilty. But when I say guilty,
You can go. You've already said that you're not guilty. I'm not going to accept you saying you're guilty under oath. That would be a lie. Honesty is something we all follow, or we're supposed to, sir. All right, that's set for trial. 23 CR 662 is called, State of Texas versus Ashley Grant, who is charged with a third-degree felony of obstruction or retaliation. And 23 CR 960 is also an indictment charging Ashley Grant with the third-degree felony of harassment of public servant. Does the defendant waive formal readings of these indictments? Can we proceed in summary?
Yes, Your Honor.
In summary, 662 alleges that on or about March 4th of 2023 in Jefferson County, Texas, you committed the third-degree felony of obstruction or retaliation involving a public servant, namely a police officer. Do you understand what you're charged with there?
Yes, sir.
In 960, this alleges on or about February 18th, which was two weeks. No, I'm sorry. Yeah, about 2 weeks prior to the event in 662, that on February 18th, 2023 in Jefferson County, Texas, this charges you with the third-degree felony of harassment of another Beaumont police officer. Both of these are third-degree felonies. Do you understand what you were charged with here?
Yes, sir.
In each of these cases, if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreements have been reached in your cases where you would be pleading guilty, placed on deferred or unadjudicated probation for 10 years on each case. Is that your understanding of the agreements?
Yes, it is, sir.
If I follow these agreements, you have no right of appeal. Do you understand of your cases? How do you plead in each of these third-degree felonies, guilty or not guilty?
Not guilty. Guilty.
Hold on, you got a not guilty followed up by a guilty. What's your final answer?
Good,
Okay,
guilty.
yeah. Are you pleading guilty voluntarily in each of these cases? And because you are indeed guilty of these offenses?
I'm guilty.
All right, I show you what's marked as State's Exhibit 1 in each case. Did you
Okay.
sign those documents
Yeah.
voluntarily? Did you understand them?
Yeah.
Discuss them with your attorney? Are the
Yes.
contents all true and correct?
Yes, correct.
State's Exhibit 1 is tendered into evidence in each of these
No
cases.
objection.
Without objection, they are admitted. Among other things, State's Exhibits 1 in each case state succinctly that you are mentally competent to enter your guilty pleas, which are freely and voluntarily made. You understand what you're charged with. The indictments have been read to you. You've read them.
Yes,
You were
sir.
guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. So help you God in each case. Is that so?
Yes, sir.
State's Exhibit 1 is made a part of the record in each of these cases. How much time in jail? I guess have you been in jail since you were arrested?
Yes, sir.
Boy, I'm looking at 662. I can't believe that kind of language from a lady
Oh. I'm sorry, sir.
you used. And to a police officer, who works for you. That's and me.
Yeah, I feel that.
Got some.
And then here in
Not yet.
960, you're shouting obscenities to the officers. My goodness. And it looks like you were maybe under the influence of an alcoholic beverage.
Yeah, I drove one time.
That doesn't make it right.
I'm sure.
Judge, for some reason, her jail card is not updated, so I don't have an accurate count of how many days she's been in jail. Let me look real quick on her warrant screen and see when that was closed out.
I'm worried. I'm more concerned about 960 where she spit on the officer on his face.
Okay, let me check that one, Judge.
You're gonna be, that's intolerable. Well, they have to face that kind of thing, but you're going to be held responsible when
Yeah.
for behavior like that, which is unsafe
Yes,
behavior
it is, sir.
under. In each of these cases, while we're figuring out, you have pleaded guilty voluntarily, you were mentally competent to do so, you understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas in each of these cases from State's Exhibit 1 to find you guilty beyond a reasonable doubt. But I am going to rather defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years on each case. There will be terms and conditions of probation which are normal and customary for this.
Looks like August the 1st of 2023, she was arrested, Judge.
Type of offense.
Looks like she was arrested August the 1st of,
You've been in custody since August.
Yes, sir.
You will serve 60 further days as a condition of probation and 960 for that very dangerous activity that you performed on one of the public servants. You don't spit on anybody, much less a police officer.
No, I would ask her attorney, she's not saying this, but I would request the court to abate that since she has done 6 months already. If the
Not as a condition of probation. She hasn't. It says they put her in at August 24th is when it's showing August 1st. So that would be, but
6 months as of.
But I think I can put 6 months as a condition of probation from the outset of probation.
You can, you're absolutely, everything right. I'm just asking the court to consider.
It's just, let me just say this. I'm just gonna say this. You don't spit on the people who represent you and me and who are putting their lives on the line. You don't spit on their face.
No.
That carries a price. K Woods, 23 CR 202 is called. Mr. Adams is here representing you. What are we doing today?
She's, it's a probation offer to accept them.
Oh, okay. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary? There we are. Can we proceed in
Oh,
summary?
I'm sorry. Yes, sir.
And she waives a formal reading of the indictment.
Yes, she would.
All right. In summary, ma'am, this indictment alleges that on or about September 21st, 2022 in Jefferson County, Texas, it alleges that you committed the second-degree felony of assault on a peace officer. Do you understand what you're charged with here?
yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached, you would be placed on deferred or unadjudicated probation up to 10 years in length. There is no fine. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
And if I follow this, you were placed on deferred or unadjudicated probation. You will be required to follow the normal and customary terms of probation for this type of offense. Do you understand?
Yes, sir.
How do you plead to this charging you with the second-degree felony of assault on a peace officer? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document?
Yes.
Voluntarily.
Yes.
Did you understand it? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea,
Yes, sir.
which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true. So help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report waived.
Yes, sir.
How long have you been in jail now?
Since August.
Just look at something real quick. I'm sorry, how much time? How many days did you say?
Um,
It was in August.
It's at least 120.
Was she? I only show that she's been in custody for 42 days unless she was arrested in another county and.
Did you post a bond or something?
I
You were
didn't-
in another county?
No. I was right here, but I was right from Hardin County
Yes.
in August,
Yeah.
August 7/23.
Hold on, Judge. Let me double check on the place.
What was in Hardin? What was going on in Hardin County?
Criminal trespass.
Okay, 157. 157.
So we're going to put you on probation here. Where are you going to live? Where
With
do you-
my mother.
Okay, and where is that going to be? You're going to see the probation officer here in a minute, but shows you are a transient, so we need to make sure we're going to know where you are at all times.
I have, yeah, I'm gonna live with my mother. I don't know what transient is.
Means you don't have a place to stay.
Means you don't have your own home. Where does she live? What city?
Nearland.
I'm going to find as follows that you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this hearing to find you guilty beyond a reasonable doubt. But I am going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation which are normal and customary for this type of offense. Please make sure you follow them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 20 years in prison. So it's important you follow the rules. Do you understand?
Yes, sir.
Okay, anything else? That is all on this case. Thank you.